The courts and the judiciary, seems like they're into everything today. They have the final word in shaping our national policies on things from health care to marriage, from the right of personal self-protection to public religious expressions, and from criminal justice matters to military policy issues. And we let them do it. We seem to have forgotten a few basic principles that are worth reviewing. For example, let me point you back to this book. This is the Federalist Papers. It's a book considered to be the most authoritative constitutional commentary ever written. In this book, founding fathers who actually wrote the Constitution tell us that, quote, the judiciary is beyond comparison the weakest of the three departments of power. Wait a minute, the judiciary, beyond comparison, is the weakest? Really? In fact, the Constitution made the judiciary so weak that according to the Federalist Papers, quote, the general liberty of the people can never be endangered from that quarter because, as they point out, the judiciary, quote, has no influence over either the sword or the purse, no direction over either the strength or the wealth of the society, and can take no active resolution whatever, and may truly be said to have neither force nor will. In fact, they tell us that, quote, there is not a syllable in the plan, that is the Constitution, which directly empowers the national courts to construe the laws according to the spirit of the Constitution. Wait, the Constitution makes the judiciary the weakest branch, and they have no direction over our public policies, and the Constitution does not authorize them to judge laws according to the spirit of the Constitution? No wonder progressives don't like the Constitution. It restrains them. They don't like being held back from fundamentally transforming the country. It's no wonder that they work so hard to keep the Constitution from being taught in schools. In fact, have you seen what happened in the high school advanced placement textbook? Look at how they handle the Bill of Rights and the Constitution. For example, the Second Amendment here, the people have the right to keep and bear arms in a state militia. That's not what the Second Amendment says. Yeah, but that's what progressives and liberals wish that it said, so they just simply rewrite it to make it the way they want it. Former Supreme Court Chief Justice Charles Evans Hughes explained this philosophy in these words. He said, we are under a Constitution, but the Constitution is what the judges say that it is, or the teachers or textbook writers, whoever. Thomas Jefferson long ago warned us what would happen if we let the Constitution be interpreted solely in the hands of activists who don't like what it says. As he explained to someone back then, he said, quote, you seem to consider the judges as the ultimate arbiters of all constitutional questions. In other words, the belief was that judges were the ones who would get the final say on what was and was not constitutional. But Jefferson continued saying that this is, quote, a very dangerous doctrine indeed. The Constitution has erected no such single tribunal. As he pointed out, quote, the Constitution, on this hypothesis, is a mere thing of wax in the hands of the judiciary, which they may twist and shape in any form they please. The Constitution, a mere thing of wax in the hands of activist judges. Yep, that's what it's too often become. We've forgotten the warnings of founding fathers such as Constitution signer Rufus King, who declared that, quote, the judges must interpret the laws. They ought not to be legislators. This is why the founders did not give much power to the courts. But we've drifted. We need to go back and study the Constitution. As John Jay, an author of these very Federalist Papers and the original Chief Justice of the U.S. Supreme Court, as he reminded us, he said, quote, every member of the state ought diligently to read and study the Constitution of his country. By knowing their rights, they will sooner perceive when they're violated and be the better prepared to defend and assert them. Every one of us must study the Constitution so we can know what is right, and then we can defend and assert what is right. Now, in this area, we ought to study the Constitution so that we can know the way our judiciary was originally designed to operate. Well, unfortunately, we're clearly not there today. So let's deal with where we are today. We're going to look at an update today on several major issues now in the courts. What the courts rule on these issues will have an impact on all of us for decades to come. In other words, what we're going to cover today is big stuff. One issue that we'll look at is how kids on university campuses, and I mean particularly the conservative or the Christian or the Jewish kids, how they're being attacked in unbelievable ways by liberal and progressive universities and professors. We'll see how cases defending those kids are doing in the courts. We'll also look at court cases that have some great attorneys attempting to level the playing field and take away the institutional advantage that liberals currently have in the area of campaign financing. And we're going to look at cases proceeding through the courts right now that may literally destroy Obamacare or at least radically weaken it through conscience protection provisions. And you may have noticed that right now, our U.S. military's soldiers and sailors and airmen who hold and express their personal religious faith, they've become a target under the Obama administration. We'll see what's happening on that front. And finally, we'll look at cases dealing with the recent IRS abuses and the way that the IRS targeted specific citizens and groups merely for the political viewpoint that the IRS suspected that those groups held. By the way, before looking at this IRS issue in the courts, let me just mention a historical perspective on an IRS-related item from the Constitution. It's the Fourth Amendment. The Fourth Amendment of the Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, many today, including many conservatives, think they know what the Fourth Amendment means, and maybe they do. But you know, the best way to fully understand this or any other part of the Constitution was given long ago by an early U.S. Supreme Court. And they said that in order to understand the intent of any clause in the Constitution, that what we must first do is to determine what they said, quote, was the evil which was intended to be remedied. Now that's smart. So if you want to know what it means, figure out what the evil was they were trying to fix. So the Fourth Amendment was designed to remedy what problems? Well, the Fourth Amendment behind it, a lot of the problem was the British use of what were called writs of assistance. In the decades leading up to the American Revolution, British officials in America would take a writ of assistance, which is kind of like an open-ended search warrant with nothing specific written on it, it's not filled out. They would walk into private homes and businesses and demand to inspect the colonists' private possessions and belongings. Now, those officials would search and they would dig and search and dig until they found something they could claim was illegal, and then they'd fill out the writ or the search warrant after the fact. Now, this practice gave government officials an unlimited power to search what the Fourth Amendment later identified as citizens' persons, papers, and effects. The founders hated this practice, and so they created the Fourth Amendment to forbid it. As a result, no government official can inspect any citizen's persons, houses, paper, and effects without a search warrant signed by a judge and signed only after someone has attested to a probable knowledge that a specific offense has been committed, and then the warrant has to specifically describe exactly what they're looking for. But today, because we don't know the historical writ of assistance or what it is, think about what happens when an IRS audit. Now, you receive a letter or a phone call from an IRS official demanding to see your persons, houses, papers, and effects. They then begin searching all of your bank statements, all your check stubs, all your receipts, everything else until they find something wrong, and then they punish you for what they found. Now, they didn't know there was anything wrong when they started, but they searched your persons, houses, papers, and effects without any authorization signed by any judge. You know, if we really understood the writs of assistance in the Fourth Amendment, we would say to the IRS or any other government agency, you want to audit me? Fine. Just get a judge's order specifically detailing the probable cause that makes you think that I'm guilty of something, and then have that warrant specifically list which check stubs, which bank statements, and which receipts you want to see. And if I don't see that judicially signed warrant, you don't see my persons, houses, papers, and effects.